upon the private opposite party is not complete, comma?
Not
The
today, but Lordship, today, order pass not today, Lordship, if you.
Can you come back with the affidavit of service tomorrow?
Tomorrow. They will try that.
Not today.
Item number 7.
Hearing for the petitioner, my lord.
Yes,
My lord.
virtually.
My lord, 7 and 8 may be taken up together, my lord. Stay order. Mr. Pal is on the way. He would be tendering the affidavit of service.
I do not find anyone here.
My lord, can you pass it over if it is possible for a moment?
7 and 8.
7 and 8, my lords.
Very well, passed over.
My lords.
7 and 8 passed over.
Well, I'm appealing for the, it's an appeal against the order of acquittal, judgment and order of acquittal. There was a delay of 258 days.
Have you served the?
I have served twice. Last occasion, state has been directed to inform the accused person for regarding the appeal. But
Lordship, we have already intimated the IO, but we have not got the information from the other side, Lordship, that whether they have been successful or not regarding the service, Lordship.
more than a year I've been, my appeal is not.
When can you come back?
Lordship, since today is Thursday, I'll come back on Monday, Lordship.
Monday?
Yes, Lordship.
Learned Counsel for the state seeks accommodation. Let the matter appear under the same heading on 23rd December.
23rd December.
Please submit a report on Monday with
Monday,
regard to the
I'll submit a
service.
report. Yes, Lordship. I'll submit a report.
Next.
Item number 10.
Yes.
Lordship, this matter pertains to an proceeding under domestic violence. Lordship,
You are appearing for the husband.
I'm no, Lordship. I'm the in-law, sister-in-law, and husband of the sister-in-law. Lordship.
Which is the order that you've challenged?
No, Lordship, I have challenged the entire proceeding.
So in that case, you have to serve and come back.
Lordship, I will serve and come back, but my ear should be admitted.
Yes. The petitioners seek quashing of proceedings, being Miss Case 144 of 2024, pending before the learned judicial magistrate, third court, Siligna. Paragraph, the petitioners are directed Petitioners are directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter will be placed before the next available.
Lordship, can I pray for a short stay of this?
You don't require a stay. Why do you require a stay?
Because date is fixed on 23rd of December
For
appearance.
caveat appearance, you don't need a stay. Serve and come back, it will be dealt with. You need a stay only when there's a date for payment.
Lordship.
So that's not the case here. Next.
11.
11, no one.
I've been praying for short passover. 11.
Passed over.
12.
Well, Lordship, Mr. Owen Vanat is on the virtual mode.
Yes, where is Mr. Banerjee?
On my Ache.
Hmm?
Passed over the
Motion stage?
motion stage. Passed over.
Passed over.
13.
13, I'm praying for not to go.
Not today.
14.
I have challenged the order of proclamation, Lordship. It has not been complied with the statutory requirement. So the impugned order 37. Impugned order dated 37. Order dated 26 of April 2022. I have annexed all the documents. Kindly see, during the course of the investigation, the prayer for. Kindly see first page 21 of my application.
What has been issued?
Yes,
WA, WP together? Wonderful.
the first, can you see page 31 of my application? Order number 31. During the course of investigation, first prayer for issuance of warrant was
Page?
curiously prayed. Page 31.
Yes.
During the course of investigation, prayer for warrant of arrest was prayed for, that was allowed. Though he was empowered to arrest the person, but they deliberately prayed for issuance of arrest. Subsequently, page order number 32 on the within less than 1 month, okay, 5 or 10 days, then prayer for proclamation was sought for. The next page, order number 32, prays for proclamation and issued WPA.
Where is the NER?
What's it?
Where is the
No,
NER?
no NER, no NER. And order number 33, next order.
Oh, executed also.
No, received, no, Lordship, can you see, issue first WPA, again, and receive a report on execution or proclamation. Execution of proclamation. I don't know, Lordship, what do you mean? Then, Lordship, can you see, go directly to the order number 36 at page 35 of my application. In the middle portion, order number 36 at page 35,
Yes.
in the middle portion, WA and proclamation is not received. And then issue reminder. Then on 10th of June 2022 for WA and proclamation. And that then on thereafter the impugned order dated 26th of April 2022. And then the investigating officer immediately paid for declaring the 7 absconding accused person for issuance of proclamation and non-bailable warrant of arrest, and that was allowed.
And what is this permanent non-billable?
I
warrant?
don't know.
We have so much to learn. still. Well, I'll stay this order, please serve.
And all consequential order also subsequent.
The petitioners have assailed the order passed by the learned additional chief judicial magistrate, Mathabhanga, Coach Bihar on 26 April 2022 in GR case number 311 of 2021. Whereby the learned magistrate has directed issuance of inverted comma মধ্যে লিখুন permanent non-bailable warrant of arrest. Against the petitioners and other accused persons of the case. Paragraph. It appears from the record that during investigation of the case, the investigating officer prayed for issuance of warrant of arrest against the accused persons, including the petitioners, and warrant of arrest was accordingly issued on 24th January 2022, fixing 18th April 2022 for execution return. Stop. A further prayer was made by the investigating officer for issuance of warrant of proclamation, and such prayer was allowed by an order passed on 8th February 2022. Without waiting for the execution return of the warrant of arrest scheduled on 18th April 2022. by the order impugned, comma, the learned magistrate has directed issuance of inverted comma মধ্যে permanent non-bailable warrant of arrest comma, the term being alien to law. Paragraph. The matter needs to be heard in presence of the state. Paragraph. The petitioners are directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph. In presence of the opposite parties, state that. Severe words. Notice, service direction. Paragraph. Let them at, the order impugned dated 26th April 2022, passed by the learned additional chief judicial magistrate, Mathapanga, Kuch Bihar. In, oh, this is special case number.
Yes, yes.
শুরুতে GR বলেছিল, special case number 8 of 2022, first line of judge. Special case number 8 of 2022, be stayed till 31st January 2025 or until further orders, whichever is earlier. Paragraph, the matter be placed before the next available circuit.
It can be extended to April, February, because why I'm telling you, CBI perhaps will not appear for first day audit and service to be effected by their head office, and it will take time.
You have more than 1 month's time.
Yeah, yes, true.
Serve immediately, because this has to
Exactly.
be quashed.
I
Why
understand.
do you want to wait?
Absolutely, absolutely,
A
Great.
ridiculous order.
absolutely. Great.
No, order is still illegal order.
Item number 50.
My lord, in 15, I appear for the petitioner. My lord, I have a small request to make. I want to do this matter physically before your lordship on Monday, my lord.
Monday, there are loads of matters before this bench, so you can take a chance.
My lord, kindly keeps it on Monday. I'll try my luck.
Learned counsel for the petitioner seeks accommodation. Paragraph, let the matter appear under the same heading on 23rd December 2024.
I'm deeply obliged, my lord.
Next,
No, item number 16 and 18, my lord, both are the similar kind of matter, because my lord, item number 16 is case lost by the wife, and item number 18 is case lost by the husband. Now
Yes.
both, they have mutually amicably settled their issue. Now,
who is appearing for the other side?
my lord, is item number 18 for the wife. And for the item number 14. Is the case under section 419, 325 and 506, and my lord, the husband
Have
has-
you filed a joint compromise application? Do you want to file one? When will you come back? Tomorrow? You can come back with, they are local people, right? Come back with the joint compromise tomorrow. I'll request the state to record the statement of the victim girl, victim lady, so that I can dispose it of on Monday. Yes. Because we have a very, we don't have much time this side, right?
Fine.
And since it's compromised, should be disposed of. Learned counsels for the parties submit that the dispute has been amicably settled between the parties and the private opposite party does not intend to proceed with the matter any further. Stop. The parties seek to file a joint compromise petition tomorrow, comma, that is, comma, on 20th December 2024. Paragraph, let the matter appear under the heading to be mentioned on 20th December 2024. Tomorrow to be mentioned, be ready with the petition. 16 and 18, same order is being passed. Remember, 16 and 18, same order. Seventeen.
Item number 17.
I'm for the petitioner also. So I have challenged the proceeding on a ground that the self-same cause of action, 2 cases have been counter case and cross case have been filed. Investigation, both are investigation are purportedly being carried out. Few of the accused person in both the cases have been released on bail. The thing is that no common investigator has been appointed. 2 separate investigators are investigating simultaneously. My humble submission
The
in terms
issue
of
is the same.
issue is the same date of cause of action and allegation more or less same. Case, cross case. Honorable Supreme Court has laid down a law that when a case and cross case are being registered, then the common investigator should appoint and he will carry out the effective.
In order to avoid conflict of decisions.
Exactly,
Yes.
exactly. This is
So
the judgment.
why don't you serve and come back? Give this to me on the next date. You are appearing in this.
No. They need to serve.
Please serve and come back.
That's it. Monday.
Because only the state should be the
Exactly.
opposite party.
Exactly. No,
No.
private respondent are also there.
Can you serve them by Monday?
No, Monday can't be possible.
Next circuit.
And also next
Very
circuit-
short matter you have to serve.
Anything.
The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed before the next available circuit.
Interim order.
Why?
Interim order.
You don't
Because-
need to let it continue. 2nd January is the next. Matter can be disposed of. No interim order is required. There will be an order for amalgamation. That's all.
Yes.
Next.
Item number 19.
Petitioner, no one, not today.
20.
My lord, for item number 20, I have got the opposite party.
My lady, I'm praying for next circuit in this one.
Next circuit.
Next.
On prayer of the petitioner, the matter be placed before the next available circuit. bench. Next.
21.
21, I'm for the petitioner. See, this is a case, just like a previous one. Slight difference is that this is a case and counter case has been registered suo motu by the police on a consequence of the first transaction, first date of occurrence. This is the same nature of case. The cross case was registered by the police and
Yes.
where I am the victim.
There was a direction for service.
Yes,
Not served.
no, service has been effected. Service,
You've received copy? You've received- Served. Since service upon the opposite parties is not complete, comma, the matter be placed before the next available circuit. bench.
It can be straight because why I'm telling you, say tomorrow is the date. Tomorrow is the date for evidence. Short stay,
So investigation is complete.
complete. But the trial need to be joint trial. There is also guideline. No,
302 matter, I will not stay the evidence. Let it be tomorrow, 1 day evidence. 2nd January, next circuit is there. So, and this is not a question of stay. This is a question of tagging.
Tagging.
So stay is not required. Which is the earlier case? This
Yes.
one or the other one? Which is the earlier matter? This matter is earlier, it's
No.
or the other one?
This is altogether different case.
No. You say there is a case and counter case.
Ah.
So the counter case was instituted earlier or this matter was instituted earlier?
This case has been instituted later.
Oh, the counter case was earlier.
No, counter case is the second one. This is the first one. I'm
Oh,
challenging.
that's what I'm asking. Wait, wait.
22.
Well, for item, I'm doing for 1 day petition.
Not today.
23.
23 to then or 24 to then? 24.
23? No, not today.
Yes, my lord, item number 23.
23? Yes. Where is he?
He's moving a matter before the division bench, my lord. Short pass over.
There was a direction for service. Have you served? Where is the service on the private opposite party? This is the issue where the company has not been
Yes.
in.
Yes.
No, that's a settled law, not
Section 4.
14 AB, yes.
Yes,
Let me make it not today because you'll fall, sir, don't run. I
Well,
think it
this
not
lordship
today,
had
private
this-
opposite party is not there. And you say that you have served.
Yes, Lordship, here it is, there is no private.
Yes, AK
Private
Bose,
opposite party also there. AK
oh,
Bose
enforcement
collective
officer.
is enforcement
Yes,
officer.
I don't find him. The
Yes.
employment,
Only-
Provident Fund Authority,
Provident.
yesterday also he was appearing, not today only. Because he'll be engaged in that election, I think, of the party,
Yes, maybe.
not today.
Good.
Next,
24 hours, I am appealing for the state.
petitioner, not today.
Petitioner, yes. 24. 25.
In this matter, I laid by Madam Mr. Ongsuman Chakraborty, Madam, this is an application for extension of interim order, Madam. I have served.
Other side, if so,
I am for the state.
it extension heading and need event. Why is it
Have you
appearing
like
under?
that?
This is the first time extension.
No.
What about the private opposite party?
But I have served. This is, Madam, Mr. Subhashish Chakraborty, Subhashish Mishra is happening, he's in port number 1.
Is he there?
He is in port number 1. And his junior endorsed, Madam. Name. Satyajit Jain.
I'll pass it over. Since you're seeking,
Mala, he is coming. Mala, he is representing his junior. Mala, he is.
extension of interim order.
Yes, ma'am.
I'll extend it for a limited period,
For a short period of time.
31st January.
We are ready for hearing.
Affidavit of service, heard learned counsels for the parties. Paragraph, the interim order granted earlier is extended till 31st January 2025 or until further orders, whichever is earlier. The matter be placed before the next available circuit bench, grand disposal. अच्छा, ওটা available circuit bench টা কেটে দিল। শুধু extensions. Hearing nothing. ওই লাইনটা কেটে দিল, না। Grand disposal. For a mention.
Let's state present.
Yes, give your names. Next,
26. No, 26, I am for the petitioner. While leave is required, my lord, I have annexed this certificate copy, which is not, my lord, properly, my lord, not proper in my hand, my lord, which order which I challenge, my lord, your lordship given leave, then I,
file a supplementary affidavit.
my lord, this first time listed motion, not even served.
Yes, so
My lord,
file a
this is impugn-
supplementary. I'll make it not today,
Yes, my lord.
or I'll grant you leave to file supplementary affidavit annexing the document. Yes, you can come back by tomorrow.
Yes.
Because it's, no, none appears for both the
My
parties.
lord.
sir.
My lord,
Issue notice. It's a direction for service. Have you served?
no, my lord. Then make it,
12th November order issue notice.
my lord, then make it, my lord, then one leave may be granted to supplementary.
Yes, yes, I'll grant leave and
And
place it
next-
for next, yes.
My lord.
On prayer of the petitioner. Liberty is granted to use a supplementary affidavit annexing relevant documents. Paragraph, since service upon the opposite parties is not complete, comma, the matter be placed before the next available circuit bench.
And if
Next,
Number 27.
not today.
In this matter, on the last occasion, there was a direction to prepare a copy of the deposition of PW1 and PW2. as because the deposition of PW1, which has been PW1 and PW2, which has been relied upon by the petitioner, I'm on behalf of the respondent. So it was not legible. It was
Who is
handwritten.
appealing for the petition?
I for that. It was not legible. So the learned judge was called for, and he was present, and direction was given so that within 7 days, a legible copy could be prepared and will be handed over.
Page number 44. This was the copy.
না না আগে অর্ডারটা দেখুন
The district judge was directed to
Right.
issue typed certified
Right,
copy in
right.
folio.
now the issue is that as because they
Has
have-
this been done?
No,
Complied with?
my contention is that as because they have relied upon those documents and that is a part of the record. So if the hearing is to be done, then a copy needs to be served upon us also. As because they have relied upon those documents, PW1 and PW2.
Have you deposited the requisite fees for
Not-
this?
That also was I have to take.
There was a direction for depositing fees.
Let the matter be placed next time, my lord. In the meantime, we will whatever.
Please do the needful, because otherwise the matter cannot be taken up for you.
My contention may be recorded that I am required to get hold of a copy of that.
Not necessary, you are automatically entitled to a copy when whatever is filed before the court,
Right.
you are entitled to a copy.
Right.
That's not needed, no need to record that.
Right.
I'll place it next, please take necessary steps, because it is your matter and it cannot be taken up.
Yeah.
On prayer of the petitioner, the matter be placed before the next available circuit bench. Next.
And for the petitioner, if you have challenged an interim order of maintenance under Domestic Violence Act, this matter has been admitted by the earlier bench. Copy was directed to serve. I served it and service has been completed. The only prayer is this, that interim order has been passed to the tune of 7,000. My income is 7,000 per month. I have attached the salary slip of my at page 51 of my application. I am a cashier of a particular firm where I draw a monthly salary of 7,000.
You have come up against which order?
The interim order.
Order of the judicial magistrate?
Yes.
You have not approved the sessions court, section 29, mandatory?
No.
Then? Go back. I'll protect the limitation part. Yes? It's against the 23-2 order, interim order. Affidavit of service. The petitioner seeks liberty to, the petitioner has assailed the order passed by the learned judicial magistrate, second court, Alipurduar on 22nd December 2023 in CR case number 32 of 2023. Granting interim monetary relief to the tune of rupees 7,000 in favor of the 6,000 in favor of the private opposite, in favor of the opposite party. Opposite party. Paragraph on prayer of the petitioners, liberty is granted to withdraw the revisional application and approach the appropriate forum under section 29 of the Protection of Women from Domestic Violence Act, 2005. Paragraph. If in the event the petitioners refer statutory appeal before the appropriate forum within
after ensuing the action, after reopening of the court,
within how, I'll give you a time limit,
15 days.
within a fortnight from within a fortnight after the ensuing vacation, the learned appellate forum shall deal with the appeal on merits and not dismiss the same on the ground of limitation.
Yes.
The revisional application being Sierra such and such is dismissed as withdrawn. Urgent certified.
Such an interim prayer,
You
interim
have the
protection.
certified copies, isn't it here?
Yes, certified copy.
On prayer of the petitioners, we dismissed it. Further liberty is granted to withdraw the certified copies of documents filed in connection with the present application upon furnishing photocopies thereof.
Lordship, one humble prayer, Lordship. I was given by upon admission of this application, I was directed to make payment of rupees 4,000 during the pendency of the revision. Lordship, let the order be continue till the decision of the interim application.
The direction given in the order passed on 9 April 2024 shall continue till filing of the statutory.
Yes, grateful. Lordship.
Taরপরে dispose.
31.
Item number 30.
Lordship, I'm for the.
Yes, petition. Motion stage.
No, hearing. Lordship, remembers, today's,
State, oh, Mr. Chakraborty.
petition for that. 376.
What about the private opposite party?
Okay,
Have you served?
yes, Lordship, previously. Get to the recordings. Because the extension was also granted.
Not delivered. Addressee moved.
Move. Oh, extension would be there. Lordship,
You have a copy?
maybe I.
Because we are taking up the main application today.
Lordship. Plan applications go. Delivered.
Did not appear in the earlier.
No,
also,
Lordship.
right?
There are reasons, Lordship. If I go through the matter, Lordship will know that there are reasons.
Yes, please place your case.
Lordship. Lordship remembers on the other day, when the hearing was about to start, I have showed one document regarding the potency test of the
Yes,
petitioner.
yes.
At present, I am not on that. Let me place the fact of the case first and then the legal points why I challenge the charge. Lordship, see page
So
12.
charge sheet has been submitted.
Yes, Lordship. Page 12, that is the written complaint. And page 13 is the written complaint. Page 12 is the FIR. Finally, notes, Lordship, the
You have the CD with you, Mr. Chakraborty?
I have no CD, my lord, then,
Because the CD is required, the document that
Lordship.
Mr. Ganguly had shown, I need to see that in the CD.
Because I have the certificate copies, but it will
No,
be
no,
in the
I
case
want to
diary.
see the original document.
আগের দিনই তো বলেছিল সেই জানতেই জন্য তা কালকে my lord, tomorrow.
Tomorrow? Not today.
Grateful, Lord.
Next. Yes, 31? Where? In file.
Kindly one day about the CD, for CD already.
31,
31, Lord.
not today.
Motion, Lordship, the only issue is this, Lordship, 498 proceeding, Lordship. Decree of divorce has been passed. That I have annexed it at page 45 and 45, 46.
Not, no longer at the motion stage. It was served, he is appearing in this.
Lordship, it's true, but the interim prayer will be considered, Lordship, because decree of divorce has been issued, Lordship, and despite the same only 49 simplicity of 498 lawsuit and 34 dowry prohibition act. Decree of divorce has been passed at page 45 and 47.
So what about the private opposite party then?
What's it?
Private opposite party has to be there. How?
Yes, yes, served it, served it. Ability of service is there.
No, this is item on hold. Where is the service? Please show me. Addressee cannot be located, item on hold.
No, 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 this is the latest one. So then I.
Please show me.
This is the latest.
Service.
This
There's only one affidavit of service here.
is the latest one. I'm appending it, Lordship, today.
This is 29/7. Come back with an affidavit.
So I'm today itself I am giving. Lordship. Today, and with the course of day I'm preparing.
And in any event, I cannot pass an order in her absence today. I'll just make it not today, come back tomorrow. I'll consider this.
Monday.
Because today there's a resolution, even if this is served, if I take it that it is served, I cannot pass an order.
So Monday fixed it. Monday.
Since the petitioner is not ready with the affidavit of service, showing service of notice upon the private opposite party, comma, let the matter stand over till 23rd December 2024. Please come back with an affidavit. of service. Next. যে আলাদা করে দিলাম আপনার হাতে। Loose sheet যেটা আছে।
Lordship passed over. Passed over. Supreme Court passed.
Passed over.
Lordship, 33 and 34 are connected matters, Lordship. These are PF matters in which company has not been made an accused.
I'll make it not today because
Not-
I do not find the company's
Not-
lawyer today.
Lordship. 33 and 34.
33, 34, not today.
Praying for short passover. We don't have the brief right now.
5 passed over. আমরা ওই এফিডেভিটের সার্ভিস ওইটা না, একটা লুজ কাগজ আছে সেটা না দিতে দেয়নি। That is not the affidavit that you are taking back. That is
Affidavit of
the
service.
service, no, the loose paper that you gave today.
Yes,
This was filed earlier.
no, I would like to reaffirm that.
Let this be on record. ওইটা ফেরত দিন ওটা আর এক্ষুনি।
ওটা আমাকে দিয়েছে।
Yes,
Yes.
yes.
So may I be take out?
This is already on record. How can you take this
No,
out?
may I get it for reaffirmation? Because I will tag that latest
No,
one.
you cannot. You have to file a fresh
Fresh.
affidavit of service, yes. Because this was filed on the earlier occasion,
Exactly,
not even
exactly.
today.
Exactly,
So I cannot take out a file.
exactly.
document.
Sorry, sorry. Sorry.
কমলা কবে ফাইল হয়েছে ওটা খুলে দিয়ে দিচ্ছি। নেক্সট
36 and for the petitioner. Lordship, I have challenged an order of rejection for prayer under section 311 of the Code of Criminal Procedure made by the accused petitioner. Lordship, at the fag end of the trial, Lordship, I made a specific prayer before the learned trial court, putting a specific question to be put to the particular witnesses number PW 1, 3, and 4. I have attached the application itself at page 22 of my application, which was turned down by the learned court below by the impugned order.
313 over.
313. No, 313. Yes, 313 over. Inside the court, active person to similar and identical to the same 300 students who came for cross examination. Yes, 313 over. Law is very categorical that in the passing of the judgment, it can be allowed. Even 165 of the Evidence Act also empowered.
But these questions were within your knowledge when the cross-examination was held.
No, that's why I would not travel beyond my question that I proposed to put.
These questions were within your knowledge when you cross-examined the witness. What is the explanation for that? Why didn't you put these questions to the witness earlier?
So I don't have any instruction, Lordship, but
Isn't it?
no,
These are not
apparently
new facts.
no
These
new
facts
fact.
were within your knowledge when
Yes,
the witnesses were cross-examined.
Supposed to be, yes.
So why didn't you, what is the explanation given by you? Why could not examine the
So that is
the
true,
witness on this ground?
but so far the nature and scope of the question is that there is no attempt of latches to fill up the latches or whatever else, Lordship. This is not any attempt. That's why I should be restricted to put this particular question, not beyond that. I must be candid and categorical that I should not be allowed to put any further question. This is the particular question. This is also.
Earlier applications under 311 were also filed by you before the court. Please see the order impugned. The 9th October order.
9th October order. Two consecutive application I have attached at page 20 and 20, 21, 22, 24.
Please serve and come back.
Yes, Lord.
The petitioner is aggrieved by the order passed by the learned additional district sessions judge, Cursiong, on 9th October 2024 in sessions case number 8 of 2020, turning down his prayer under section 311 of the Code of Criminal Procedure. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the adjourned date. Paragraph, the matter be placed with the next available circuit bench.
Otherwise.
Not necessary.
Actual case is 2017.
Same matter in Kerala High Court yesterday, matter of this week, that has been dismissed.
Actually, জানোই না
Yes,
কোথায় matter.
yes, I know the matter, I've heard it. Recalling of witness just to drag the procedure, nothing else.
Come back. Let him serve. Come. I also put a few questions to clarify. Please deal with them.
Yes.
Good.
Not today.
38 days for the petitioner, Lordship. I have challenged the impugned proceeding initiated under the Domestic Violence Act. Lordship, the wife has admittedly left away from her matrimonial home, Lordship, on January 2021, and domestic violence has been filed on after expiry of almost.
The state was directed to serve copy of the
Yes,
opposite
copy
party.
has been served, Lordship.
No, the
Initial-
state was directed to serve.
Yes, that even I was directed to serve notice to the concerned police station to effect service upon the private opposite party. Lordship, that I have also served upon the concerned police station. The police station has also got the.
Yes, Mr. Chakraborty, there was a direction upon the state to serve.
As per all, smaller copy has not been served, maybe.
Copy served. Yes,
We'll just check and Malad will.
so only.
This is given to the SP Jalpaiguri, right?
Yes, not this place. This is the Tufanganj police station and Kotwali police station.
Officer in charge, yes.
Tufanganj and Kotwali police station.
It's stated officer in charge, Coach Bihar.
Request the application filed by delay.
Because
It has been officially served. Why don't you hand over an extra copy to Mr. Chakraborty so that he can take necessary instructions?
Lordship, but my.
The opposite party could not be served in the ordinary manner. The state was directed to serve.
Malad, let a copy be served to us, we'll direct the items of the copy.
So may I say one thing? I say my interim PR may be considered at least because admittedly there I got an order of a degree of restitution of conjugal rights that has not been challenged by the wife. Number one. Number two, 2.5 years from the date of his living away from his matrimonial home, this case has been registered. is a very, and with the cause of action 2.5 years back. Lordship, there is no, this is the dead litigation is going on, Lordship. There is nothing, the omnibus allegation, DB Act,
Which order have you challenged?
the order of summoning order.
Where is the order? Oh, the summons here. Where is
Summons
the,
order.
you've not, the order is not annexed.
No. Yes, in the summons have been challenged, Lordship.
And this was on 20th March 2024. What has happened after that? You
After
were
that,
directed to appear on 20th March.
yes, since I approached before this honorable court and I was directed to serve, I served it. Lordship,
We are in December. What has happened in the meantime?
subsequently, Lordship, I got an order from the server where it has been appeared that the latest order, Lordship.
Because March and December is a long time.
True, but meanwhile, this order has been passed. This is an order procured from the official server of the Learned Court.
Learned advocate has withdrawn himself from participating in the proceeding.
No, not withdrawn. Through my advocate, I attempted to appear with an intimation that revision is pending. On that occasion, this order has been passed without recording.
So after that, the learned advocate said that I'm withdrawing from the case. That has been recorded. Have you read this order before handing it over? Learned advocate for the respondent withdraws from participating. The case is hereby proceeded ex parte. I'm sure an order has been passed by now.
Definitely. Definitely, Lordship.
Why does he have to withdraw from the case?
So withdraw means,
I cannot protect without knowing the present status of the case. Serve and come back.
Lordship, can it be fixed on Monday? I'm coming with the latest order
Can
and
you come back with the report on Monday?
Coach Bihar, this is the Coach Bihar, and whether she was appearing.
Because
This first occasion-
this was also in November.
True, but I'm coming with the latest order, Lordship.
And this is not a case where you really require an interim protection.
If I
Your
am
advocate has deliberately
No,
and
not-
willfully
not-
withdrawn.
not deliberately, Lordship, since
Please see the order.
true. But Lordship, may I come back with the latest order and all?
Let
see.
him come back.
Monday,
Let him come back on Friday. Let's see.
Monday.
Learned counsel for the petitioner seeks accommodation. Let the matter appear under the same heading on 23rd December.
My lord, in item 39, I'm praying for short passover, my lord.
Passed over. Next.
I'm for the petitioner in item number 40, Lordship. Am I audible, Lordship?
You are, yes.
Yes, my lord. The matter is that, Lordship,
Lord, in this case, my lord, they are supposed to file a reply. On last two occasions, they have cleared before lordship. The earlier occasions are for
Reply for what?
I have filed an opposition, my lord.
Are you ready with your reply?
no, my lord, I'll do the hearing, Lordship.
Lord, I am not ready. The last two occasions, they have requested for reply. Lord.
They are dragging, my lord. I'm ready with the
They are
matter.
always
They
ready
have
by now,
already
my lord.
filed.
Did you submit on the earlier occasion that you don't want to submit a reply?
Yes, my lord. On the
No,
last
But
occasion,
I
I
do not
have.
find anything recorded.
Lord, kindly record
No,
this.
no,
Lordship,
on the
kindly-
earlier occasion, you sought accommodation. It's my
Yes,
order.
Lordship. Yes, Lordship.
Means
And
you have to- I'll record that you don't intend to file a reply and fix a date.
yes, tomorrow, my lord. I'm
Not
ready.
tomorrow. Next circuit, tomorrow not
No,
possible.
my lord, I'm ready for the hearing, my lord.
Not possible, the court is not ready. You ought to have stated on the earlier date only, no, that you don't want to come back with a reply.
Even I have not paid any accommodation
You
for
have
reply,
taken-
Lordship,
You have taken accommodation on the earlier date.
but not for reply, my lord.
It is
On
under
that,
that it is for reply because the opposition is on record.
Lordship.
Paragraph learned counsel for the petitioner submits that he does not intend to use an affidavit in reply to the affidavit in opposition used by the private opposite party. Paragraph, the matter is ready for hearing. Paragraph.
Can you fix it on Monday, Lordship?
Not
It is
possible.
ready with the CD, madam.
The state.
State is also ready,
Counsel for the
Lordship.
state is, the private opposite party also has to be ready. He's a party to the.
He
proceeding.
has already served the affidavit in opposition, Lordship.
Yes.
So kindly fix it on Monday or
Other
Tuesday, Lordship.
Learned counsel for the state is present with the case diary. Therefore, the matter is ready for hearing. The matter will be placed before the next available circuit bench. Hearing matters cannot be taken up on Monday. Next.
Stand for the petition. So, rejection of discharge, prayer for discharge, so it has been admitted, state, copy has been served. Perhaps my learned friend is ready, Lordship. So very short issue, Lordship, can
Give
be
me, give me.
decided.
No private opposite party?
Yeah, private opposite party was served, Lordship. Every service was there.
And I'm holding the CD, Lordship.
What about the private opposite party?
I don't know. They are telling that it has been solved, that means. Lordship.
Because it's under the POXO Act.
Okay, Lordship. Yes.
The service on the victim done. This is the father of the victim girl,
Yes, father,
Woman Sherpa.
yes.
One translation করা আছে, আচ্ছা, দিয়ে দাও।
Fine that it is served, but the person has to be represented. Since it's a POXO matter.
Kindly, may I propose one thing, Lordship? So far the case is concerned, Lordship, discharge prayer is, the victim 164, kindly peruse it, completely exonerating, medical completely lean, nothing short of, nothing, absolute term.
All that is fine,
True,
but
true.
then
What is,
the
yes, yes,
presence of the victim is required. This is a POXO matter.
I,
Charge has been framed already,
I
isn't it? So will you put them on notice once again and come back? Let the victim be put on notice.
so this is the final service should be, because
Yes,
unless
yes,
and
yes.
unless they record it.
None appears for the private opposite party despite service of notice. Paragraph, the petitioner is directed to serve notice upon the private opposite party, intimating party with an intimation that the matter shall appear before the next available circuit bench. If you don't find the opposite party, please try and serve it to the lawyer who is appearing for her
You are good.
before the trial court.
Yes.
Because of the presence is required.
No, I am not.
Next.
My lord, after the petition.
My lord, I had heard this matter yesterday. My lord, I had taken instructions, my lord. My lord, after,
Which matter is this?
my lord, that compromise part. My lord, since my lord had expressed that the opposition is coming from the bar, my lord, it would be pertinent, my lord, the opposition be brought by way of an affidavit in opposition, my lord. Because, my lord, there are several disputed questions of fact here.
My lord,
My lord, I rely upon the judgment of the honorable division bench.
my lord, so far the agreement is, he was disputing the payment,
No, my lord.
payment. My lord, the agreement
My lord, there are several disputed questions of facts, my lord. My lord, it cannot be determined without affidavits, my lord.
25 lakhs.
Otherwise, my lord, it would be just from opposition from the bar.
Below the agreement, let me finish. Agreement 32, paragraph 3. There has been an understanding by and between the parties, and as per the understanding, it has been agreed that the second party shall pay an second party is me. Pay an amount of rupees 25 lakhs only to the first party at the time of execution of this agreement, out of which an amount of rupees 20 lakhs only is adjusted towards being the gratuity amount due to the second party, number one, by the first party. And another amount of rupees 1,50,000 was only being the due salary amount of the second party, number one. And second party shall issue a check being this number drawn with respect to 3 lakhs, remaining 3,50,000.
I have seen that.
Yes,
But
and
since
that amount has been disbursed.
a compromise can be undergone only when it is accepted by both the parties.
Yes,
So when the private opposite party is denying to accept the compromise, the matter has to be.
Below the order passed by the larger court, by the lower court, that he has accepted the agreement, and this same Asis Diluka, he lost the FIR, he entered into the agreement, and he filed an affidavit before the court below.
But no
This is-
NOC for, my lord,
this-
there are facts that are disputed now, my
wait,
lord.
wait,
I cannot
wait.
make objection from the bar, my
But
lord.
this
Let
is-
it be brought by
This
way of
is-
affidavit.
This is why you are delaying? This
I'm
is
not
the order
denying.
of the
That's
court.
my instruction.
Want to come back with an affidavit?
Yes, my lord. My lord, this
What
is
was
a
the
vexed
purpose of
question
the
of facts,
affidavit?
my lord,
What was the
because, my
purpose?
lord,
Only to delay.
I do not want
Only
to object from the bar,
only-
my lord. Let it be from the
Only-
parties, my lord.
The other side retracts from the compromise, it cannot be affected.
He has filed an affidavit before
My
the
lord,
court.
my submission, this
Can
is
you
a
deny
serious
this
breach
fact?
of the agreement, my lord. That
Do
is
you
my
deny the existence of Asis Diluka? Do you deny the
It will be brought
affidavit?
by way of affidavit.
How could it be? Why?
My lord,
Why should
I
it
have-
be?
My lord, I have given a
Why should
judgment
it
of
be
the
dragged?
honorable division bench. The
The
it is
lower
a settled
court-
principle
yesterday
whenever
he
there
was
is a
saying-
vexed question of
Yesterday he
facts.
was telling something else.
No, my lord.
Now he has made up
I have
something
not,
else.
no, my lord. I
This
had
is-
told my lord, I'll
this is
take
a-
instructions, my lord. I have got to know from the parties that there are disputes, questionable facts.
The observation
If I
by
make
your
a submission
lordship
here is not
yesterday-
acceptable, my lord. Let it come by way
Yes,
of
sir.
affidavit.
The observation by your lordship yesterday that your client is saying something different and you are saying on your own.
No, that's what, sir. Let it come by way of affidavit from the parties.
Let him come because
No,
there is some
Can
anomaly.
you see the
Let him
tape?
come back with an affidavit.
Miley, kindly see the tape. This is
But
tampering.
there is an
that, sir.
admitted
When
embezzlement
the
to the tune
client
of
is
10 crores.
retracting from this, let him come back with an affidavit.
Let the
That
party
will be
bring their
decided by
opposition, my
courts
lord. That
with
is my
law.
submission.
What purpose will be served? What more they will do? You will get the matter dragged. What purpose it will serve? Because there is no case. They have executed an agreement and they have filed an affidavit.
He has the authority to rescind the earlier memorandum.
That has not been rescinded. That has not been rescinded by any means, by giving a notice, by
As
retracting
far
from
as I
the.
can recollect, learned counsel had said that he's taking steps for that, I think. That was,
Yes,
you
yes,
said
yes.
that.
Narazi
yes.
was-
Yesterday he said he's
Yes,
no,
my lord.
nothing of that sort. He has not filed
Let
any
it be
Narazi
by way of
petition. He has
affidavit.
not
That's
given
what
the-
I'm bringing.
Wait, brother.
I
He has
don't
not
want to
given
make a
the
simple
notice.
submission from the bar, my lord.
The execution of
Let
the
him
agreement.
come back with an affidavit. The learned counsel for the opposite parties submits that, private opposite parties submits that though a memorandum was executed by and between the parties with an intention to settle the issue amicably, there has been subsequent disputes and differences between the parties, for which the private opposite parties have decided to rescind / revoke
Today itself.
/ revoke the said memorandum. Learned counsel for the private opposite parties seeks to use an affidavit in opposition stating the entire facts.
Private opposition.
Private opposites. Paragraph, the matter we affidavit in opposition, we file within 2 weeks. Within 2 weeks from date. Affidavit in reply, if any we file within a week thereafter, in case you need to give a reply to it. Paragraph, the matter be placed before
1
the.
week, 1 week, 1 week, 1 week.
And there is a vacation of 1 week.
the vacation. So he gets 1 week.
He wants to get it tracked as long as possible. That's the whole
He wants to
intention.
siphon
He's
crores
interested.
of rupees and run away, man.
For the time
That is the
being,
whole
liberty to-
intention.
Next application.
I don't have to speak of him.
Unfair.
Let the matter go out of his for the time being, liberty to bench.
Yes.
Next.
Oblige.
Well, I am for the petition.
Yes, petition.
Yes, my lord. Even a stay of warrant, I was on bail, my lord. I also annex ordered date of bail, my lord.
Case diary, trial court records. What is the order that you're challenging?
I'm
The-
challenging, my lord. Order dated, my lord.
15/11/2017.
15/11/2007. I was on bail, my lord, granted bail. I also annexed certified copy, my lord. 26/2 of 2015. Bail
Give them.
granted by the. There is a miscommunication.
You're not annexed the certified copies.
No, sorry, well, P2. Maybe P2 is the,
11.
well, P2 is the order date of bail. 26/2/2015, my lord.
You are absent without steps.
Yes, my lord, absent with those.
2017.
My lord, there's a,
And you've managed all these years.
oh, my lord,
When
there's
did you file this application?
my lord,
24.
my lawyer did not, there is a miscommunication. He is a migrant labor, went to another state, there is a miscommunication. For this reason, my lord, this is happening, my lord. My lord,
When will you surrender?
my lord, ready to surrender and, remain.
No,
My
no.
lord, my.
17/24 remains same bond.
My lord, any other
Pray
string
for
put,
bail.
my lord,
No, no, no.
my humble
Not
submission.
no, no, not at all.
My lord, any other stringent condition? Meeting the,
Dismissed.
my lord, meeting with the, my lord,
Nothing, nothing. All the conditions will be imposed by the learned trial court. Let him surrender. 7 days.
my lord,
7
my lord,
days.
any other stringent condition so that I.
Stringent condition is applying for bail.
My lord, this migrant
When will
labor,
you surrender?
poor person, my lord,
When
what
will
is-
you surrender?
15 days time.
Let him surrender.
My lord,
And pray
bail-
for bail, the learned court will consider. The
bail-
petitioner has accepted the order passed by the learned additional sessions judge, comma, first court, comma, Siliguri, on 15th November 2017 in sessions case number 19 of 2015, directing issuance of warrant of arrest against him. Paragraph, heard learned counsels for the parties. Paragraph, it appears that the petitioner was on bail and failed to appear before the learned trial court on 15th November 2017 without steps for which warrant of arrest was issued against him. Stop. The petitioner undertakes to surrender before the learned trial court within a fortnight from date. Stop. Paragraph. If the petitioner surrenders before the learned trial court within a fortnight from date and files an application for bail, comma, the learned trial court shall deal with the same in accordance with law. Paragraph, in the event the petitioner fails to appear before the learned trial court within the stipulated time frame, comma, the learned trial court shall be at liberty to take necessary steps against the petitioner in accordance with law. CRR disposed of, etc.
Lord.
Next,
My lord's item number
Fine.
4.
stay the warrant of arrest for the time being. I'll stay the warrant for the time being. Dispose of it, आगे करूँ? এগুলো পরে, huh? Dispose of it आगे. The warrant of arrest issued against the petitioner be stayed till today's 20th. 2 weeks takes us to stayed till 6th January 2025. Next.
My lords, will kindly allow me to appear online for item number 40.
Yes.
Grateful, my lords. My lords, this is the same PF matter, my lords. Yesterday, the arguments had begun for this matter.
I'm afraid the PF authority is not there today. I'll just make it not.
Grateful, my lords.
Yesterday he submitted that he'll be busy with the elections.
Yes, my lords.
Yes. So
Yes.
not today only. Come
Yes.
back to.
Grateful, my lords.
Next.
Because I am reminding your lordship, this is that matter lordship.
Yes.
This is that matter lordship, the couple had a romantic relationship.
And they have married. They've got married.
Married and thereafter down. So then the compromise has arrived at, that compromise is going to aside. Now, protest petition filed, Naraji allowed without no reason. Lordship had proposed to me that it be remanded with a passing of a reasoned order.
Let me hear the statement. What is your instruction in this regard? Yes, what is your instruction in this regard? Because learned counsel says that the registration happened. After that, there was an assurance for social marriage. We did not announce.
Let it be recorded and
She voluntarily?
no, if he says so, then it should be recorded and I'm ready to go with him. If he recognizes me as a wife and he dealt with properly, I'm ready. I'm telling you, because I have a specific instruction that she wants very emotionally to reunite with the to reunite with his family member and his husband. Because only because
And the husband is not eager to take her.
yes, exactly. No, marriage in paper, no social marriage, nothing.
Registration is the marriage.
Only paper. That's what I'm telling. Only to get an ambiguity bill. Only to get an ambiguity bill. Bill allowed.
My lord, by intention is my lord, why 482, my lord? As per the new act, my lord, section 268 of PNSS, my lord, there is a specific provision for discharge with a petition. So why 482? There is a specific provision is there. 268 of BNSS.
You can in fact approach the trial court for a
My
discharge.
lord, my lord. My lord,
You'll have another forum, isn't it?
yes.
If this is turned down, you have the Delhi court, nothing in between, isn't it? So if you go back to the trial court, file an application for discharge on these grounds. Because what can happen is, in addition, the trial court can call both the parties. I was actually minded to call the couple and speak to them in court,
My lord,
but let the trial court do that.
my lord.
No, the revisional application will be withdrawn.
What is the necessity?
If it is remanded and the same order is passed, the trial court can call both the parties and speak to them. If they are agreeable, on that ground it can be done. The trial court can do that, and I would request you to request your advocate on record, whoever is there in the trial court, to take steps for calling both the parties in court.
Yes. And if my learned friend says so that he is.
And then both the parties can file a joint application saying that they want to lead a conjugal life.
Yes. Recording,
Isn't it?
recording.
I will only allow him to withdraw this and permit him to file a discharge application before the trial court. And record your submissions that both the parties are ready and willing to start a new life. That is your submission also, isn't it?
Yes.
Yes, Mr. Chakraborty, let me do that. Let me do that.
Mother.
Affidavit of service. Paragraph, heard learned counsels for the parties. Paragraph, learned counsel for the petitioners submits that during pendency of the case before the learned trial court, the first petitioner has married the private opposite party You've annexed the registration certificate.
Yes.
ওটা married না করে করুন। The marriage between the first petitioner and the during pendency টা বলো, তারপরে বাকিটা কেটে দিন। The marriage between the first petitioner and the private opposite party has been registered. Where is at page?
Page 21.
What is
Written on
the-
21st of June 2023.
On 21st June 2023. Paragraph per contra comma, learned counsel for the private opposite party submits that though the marriage between them has been registered, upon an assurance given by the first petitioner that a social marriage would be performed in a short while, and the first petitioner would take her to his house for leading a marital life together, the social marriage is yet to be performed, and the first and the petitioners are no longer inclined to accept the private opposite party as the wife of the first petitioner or perform the social marriage.
After securing ancillary bail, showing this marriage certificate.
In fact, the petitioners have obtained anticipatory bail upon displaying the marriage certificate, which has not been acted upon subsequently.
Yes.
Paragraph. Learned counsel for the petitioners seek in reply, learned counsel for the petitioners submits that the petitioners are ready and willing to accept the private opposite party in their family as the wife of the first petitioner. Paragraph. Learned counsel for the state submits that the petitioners may be granted liberty to pray for discharge before the learned trial court file a joint compromise petition before the trial court. The wife is ready to go. If you are also ready, file a joint compromise petition. Or if you can come back with the joint compromise before this court, I'll allow it on Monday.
Yes, yes.
Yes, can you come back with the petition tomorrow? When can you come back?
Tomorrow, no, Monday.
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 State a submission to Google. I'll record your submission. On instruction? I don't think so.
Whether joint compromise application can be filed.
At this stage, learned counsel for the petitioners seeks accommodation to take instructions as to whether a joint application can be filed before this court in this regard. Paragraph, let the matter appear under the heading to be mentioned on 23rd.
Yes.
Tomorrow, I think you have some
Yes,
difficulty. 23rd December.
Grateful.
If they are so eager to join, there should be a petition.
Exactly, that's it.
Next.
for 29.
Yes.
District judge. President judge.
There's a private opposite party also. Service complete upon him. They appeared on the last occasion, no? There was a direction for service on the last occasion. So I'll just make it not today. Very unfortunate.
That was reduced by the trial judge, my lord. To the extent 3,000.
High Court's order was reduced by the trial judge. How? How come?
That is the.
I'll just make it not today because I cannot pass an order today. There's a resolution. Come back tomorrow, I'll consider it. Very unfortunate. Unheard of. Yeah, I'll fine. Next.
47.
No one? Not today.
48.
Not today.
49.
Not today. Oh, you're there? The DB Act case? Oh. Please come back tomorrow. Today the court is, we are all little handicapped. Please give this to me tomorrow. I'll deal with this matter. Not today. Not today. Not today.
My lord, the passed over matters may be taken up.
After I complete the list.
My lord.
52. 50. The other side is not there. देखिए 50 देखिए तो ठीक আছে Respondents are not there today.
Milord, motion matter, I'll just place, Milord.
Not motion matter. The other side was appearing on the.
No, Milord. First time, Milord.
For the respondents, Mr. Rishabh Kumar and Mr. Sudhindra Das.
No, Milord. Then again, some problem is there in the file. First.
10 or 24.
Yes.
They were appearing.
Milord, wrongly it has come, Milord. First time matter is appearing before your lordship. Then some, Milord, mistake has happened in it.
Look at order sheet.
কি হচ্ছে মামলাটা?
There is an earlier order.
Milord, some mistake has happened. Milord, these names are not mine also, Milord. I never moved this matter. some problem happened, my lord, in the
Let me see.
insertion of names.
What is happening with this case? देखिए। No, I don't again Mohanlal Tamang is not your client.
Mohanlal Tamang is my file, but the names appearing as counsel for the petitioners is not mine. Neither, my lord, the respondents have
Since
been
this
served.
is an order by a coordinate bench, I cannot do anything with this. There were others who were representing.
My lord,
Serve them come-
and this is, my lord,
Inform the learned councils, come back.
no,
to
my lord,
order.
they are not the counsel for the state. The state respondents will be appearing in this matter. The names appearing, my lord, they are not the counsel for the state.
There is an,
But this is a mistake happened, my lord.
since this is staring at the face, I cannot do anything with this, right? They are not the state lawyers.
No,
Where did this, and you have not pointed this out also, this is a 3rd December order. I cannot do anything with this.
yes,
some
my lord,
other
that is right, but my lord, the,
Technically, I
Yes.
cannot touch up this order,
but
right?
my lord may hear me, my lord, since
So
it's a
what-
motion
I
matter.
cannot, since I find the others appearing, come back tomorrow, serve the state and come back. Give them a copy in a day, the state is here.
No.
Serve the PP's office, they'll, let the
PP
state
will,
appear tomorrow.
PP will not appear, but the GP section will appear in this matter, since
So
it's
this is
civil,
the
civil revision,
CO,
yes.
Anyway, this is here itself.
My lord, yes, that can be done, my lord.
Since this order is stopping me, actually, nothing else. Once I find representations and this, there was no prayer.
Then
for
my lord may
correction of the
direct
order,
service, my lord may direct service at least.
I'll do
Because,
that, I'll do that.
yes.
That is the minimum that I can do in this, yes. The petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the agenda date. Next circuit.
And my lord may
The
kindly
matter is-
record my submission
Circuit.
that the names appearing, names of the councils are incorrect, my lord.
You need a correction before the.
Just the submission be
bench.
recorded, because even my name is not there.
So
I,
you ask for a correction before the bench was passed the order, the corrections will be done. These names ought to be deleted. And
Yes.
your name has to be incorporated, which cannot be done by this bench.
that's right.
Correction has to be done by
That's-
the bench who has
that's-
passed the order.
that's it.
This is judicial propriety. I
My
cannot
lord,
pass.
my lord. About it.
Next,
Have it. Have it.
yes, please give the correct name now.
Yes, yes. I'm grateful.
Next. Next. Not today.
No, I'm for the petitioner. I'm for the appellant. The affidavit of service.
What is the application about?
Well, that's a limitation application. Moderation of legal. Section five.
Anyone for the opposite party? No,
Well, I have already served.
not today. There's a resolution,
Yes, my lord.
not today.
But kindly fixes it tomorrow, my lord.
Not today only.
Yes, at the top, my lord, can it be fixed?
The entire list is being called.
That is okay, my lord.
Next,
If it can be fixed tomorrow at the top of the list.
it will be fixed, but not at the top, after the criminal matters are taken.
Lordship.
What application is this?
Section 5, my lord, appearing for the first time.
You have to serve and come.
Yes. Can 1 is section 5.
The appellant is directed to serve copy of the application under section 5 of the Limitation Act, comma, being can 1 of 2024 upon the respondents and file affidavit of service on the agenda date. Paragraph, the matter be placed before the next available circuit bench.
Great.
Next.
I
55, not today,
56.
not today. Passed over matters.
My lord, the passed over matters, my lord. Today we are
Yes.
praying for an extension of the order what was passed by Honorable Justice
Has any
Raja.
matter been called?
Yes, my lord.
Has any matter been called?
Oh, sorry.
Have some patience, sir.
My apologies.
Passed over matters.
Item number 5.
Kindly make it not today.
Not today.
Order 7.
My lord.
This
My
is your
lord.
order?
Yes. My apologies.
Oh, 7, 7 and 8 together. Yes.
7 and 8. My lord, Mr.
So
Park.
item number 7 and 8, Lordship, I'm praying for 1 day accommodation, Lordship.
Why?
lord.
We just yesterday night we have been intimated about the
Extension of
said fact.
interim order. Why do you need time?
Lordship,
extend this
there some
for-
submissions had to be made, and moreover, my senior would like to.
I'll extend
No,
it for a
Lordship.
limited period.
Yes.
No, Lordship,
My
some
lord.
submissions had to be made regarding the technicalities of the matter. My senior would like to be present, physically present. Kindly keeps it tomorrow, Lordship. 1 day accommodation, Lordship.
Not today.
Only 1 day.
Both the matters. You are appearing in both the matters?
Yes,
7
Lordship.
and 8?
My
We
lord.
are appearing in the matters,
Bad
Lordship.
luck, sir. Not
My
today.
lord, may I submit something, my lord?
Yes.
My lord,
Yes.
may I submit something?
Yes. You are not audible.
My lord, am I
Lordship,
audible?
moreover, Lordship, a hard copy is yet to be
My lord, am I
served
audible?
upon us, Lordship.
Yes, you are. There's some disturbance. Yes.
Yes, my lord, yes. My lord, the problem would be that the bench is till Tuesday, and the order would expire on Tuesday. So I'm asking
Tomorrow,
for a
I'm saying,
limited
sir.
period stay. We will finish it up as soon as possible.
I'll just make it not today. Come back
No,
tomorrow.
my lord, they will file a.
They want to make some submission
Very
on
well, my
this.
lord.
So let them come back tomorrow. I'll just make it not today.
My lord.
Both the matters. And they
My
have not
lord.
received a physical
My
copy of the application. Please serve in the meantime.
Yes, Lordship.
My lord,
I would require the affidavit of service tomorrow.
My lord, the affidavit of service may be taken into record. Mr. Pal would be handing over all the affidavit of service.
No order is being passed today. Both the matters not today. Next.
Grateful, Lordship.
11.
Item number 11.
My lord, in this case, I have challenged the order dated 22nd May 2024. Prior to submission of charge sheet on the proposal of the impugned proposal of the IO, the Learned Trial Court is to issue WA against me. And subsequently, the charge sheet was filed on 3rd June 2024. I am praying for the stay of the operation of that warrant of order. And subsequently, my lord, they have sent a non-execution report and WPA has been issued against me. That is order dated, my lord.
You are Mintu Sarkar.
Mintu Sarkar, my lord. ইস্যু WA করলো এইখানে 22 This case initiated on my lord.
When will you surrender?
My lord, after vacation, 15 days at least.
Surrender and pray for bail.
My lord, my lord. After vacation, at least 15 days may be allowed.
Because proclamation attachment, everything is over.
My lord, now it's very astonishing that without submission of CS, they prayed for WA is issued. They are overactive. Non-execution report was filed, WPA was issued.
And you have not challenged those orders. You have challenged only the 22-5 order.
My lord, that is the base mother order on the basis of which the WA was issued. I have challenged the order 22-5 and all subsequent orders passed thereon. After vacation, maybe 15 days, maybe time may be allowed, my lord.
The petitioner is aggrieved by the order passed by the learned Special Court, Alipurduar on 22nd May 2024 in special case 28 of 2024 and all subsequent orders passed therein paragraph, it appears that warrant of arrest was issued against the petitioner. V-Day order dated
22nd May, madam.
22nd May 2024.
My lord, it is very astonishing. With a period of 30 days, they have filed a non-execution report, WFP as well.
That is not really illegal.
No,
That
that
is
is
within
illegal, but
laws.
that is not regularized.
Yes.
That I am saying, subject to your lordship's correction. that is not-
Surrender. Since all this has
No.
happened, surrender.
My lord, my lord.
Uh, Third warrant of arrest, the warrant of arrest was issued. V-Day and order dated, order dated 22nd May 2024, and upon receipt of non-execution report of the warrant of arrest, comma, warrant of proclamation and attachment was issued by the learned trial court on 12th June 2024. Paragraph. Simultaneous issuance of warrant of proclamation and arrest is in violation of the provision laid down under section 82, 83 of the Code of Criminal Procedure. Stop. However, comma, the warrant of proclamation and attachment has already been executed. Paragraph, the petitioner undertakes to surrender before the learned trial court within 2 weeks after the ensuing vacation. Stop. If the petitioner surrenders before the learned trial court within 2 weeks after the ensuing vacation and prays for bail, comma, the learned trial court shall deal with the application in accordance with law. Paragraph, in the event the petitioner fails to surrender before the learned trial court within the stipulated time frame, comma, the learned trial court shall be at liberty to take necessary steps against the petitioner in accordance with law. See paragraph. This is all executed, no question of staying. CRR disposed of, as I said.
I mean, then I have been arrested. But it's an order of the factor.
So surrender within 7 days, that's why I've said. Surrender within 24th December. It is already filed for the present, so. Yes. আগে ফাইলটা আরেকবার দিন। আগের ফাইলটা আরেকবার দিন। আগে যেটা অর্ডার করলাম। January is for consideration of charge. Yes. So in the meantime, surrender. Next. 12. Stay prepared. Not today. $32. Not today.
32, I am for the state.
$35. So when there is an allegation, he has to face trial, isn't it? What are you asking for? What are your grounds for caution? Only because he's a teacher, that cannot be a ground for caution. Then what is your ground? You have not annexed the 207 papers also. Charge sheet has been submitted. 2010 and charge sheet submitted in 2014. 4 years. Order sheet at page. Charge sheet was submitted on in 2014. It has been placed in 2024 after 10 years. You are on bail. You cannot show me anything to suggest that the case is not, it's frivolous. Because since charge sheet has been submitted, I need to see what has happened in the investigation. This is not the FIR stage. So you say that you have not received copies, 207 copies. So the CD has to be produced. Serve and come back, let the CD be produced on the agenda. No, on what ground? When is the next date? That is also not recorded here. The petitioner seeks quashing of proceeding being GR case number 2205 of 2010, pending before the learned Chief Judicial Magistrate, Alipurduar. Paragraph, the petitioner is directed to serve copy of the application along with annexure thereto upon the opposite parties and file affidavit of service on the urgent date. Paragraph, the matter be placed before the next available circuit bench. Paragraph, case diary be called for on the urgent date. Please mention this when you serve the state, that the case diary has been called for. Next.
No, my lord, in this case, we have challenged the order passed by the learned subdivisional magistrate of issuance of search warrant ex parte against Mr.
Have you served the private opposite party?
My lord, already filed the affidavit of service.
I'll just write. I can deliver to A. Roy security personnel. Who is that?
There is, he is residing at a flat. I think last occasion, the opposite party was used to appear with you. The sharp about it.
I'll just make it not today. Please inform him and come back tomorrow.
My lord,
You're
as
a
your- Yes, I am happy. As your
because today in any event, in absence of the opposite party. I
As
cannot
your
pick up-
lordship, as your lordship.
Please inform him so that I can.
My lord,
pick up
I will,
tomorrow.
I will. Grateful.
Over for the day. Afternoon. Over for the day, no
Your
work.
lordship.
So tomorrow all will come together.
Yes, lordship.
Anyway.